Kentuckians need to understand that Kentucky is in a very unique place in the history of bail reform, because in 1976, the General Assembly made the decision to eliminate commercial bail bonding, which means that Kentuckians today, probably very few have a memory of a time when our state had commercial bail bonding. It's still an industry that is very much alive and well nationwide, but Kentucky is one of those places where we don't have commercial bail bonding. The legislature set up a system to deal with the setting of bail and created a pretrial services department that was assigned to the judicial branch. And so since the past 30 plus years, the court system has been responsible for administering pretrial in Kentucky. Across the country, there is a growing movement for pretrial reform, for pretrial justice reform. And so we're really kind of at the center of that. Because of our unique situation, Kentucky is uniquely positioned to deal with what is, in my opinion, a problem that should be addressed.
So what would bail reform look like in Kentucky, and who would it most impact?
Well, it will impact not just the people, of course, who are incarcerated, which, of course, would be direct beneficiaries of any change, but the communities all across the state would be affected. The system, as it has grown to exist, pretty much the default position in every county in the Commonwealth is that money bail, financial bail, is set. A bail bond is set in nearly every case. In some counties, it's set in every case, which means that if you don't have the money to pay the bond, you go to jail. And what we're finding is that in the jails all across the Commonwealth today, 90% of the people incarcerated in the county jails are incarcerated there not for serious crimes, not for A, B, or C felonies, which most citizens would suspect they're there because they're hardened criminals. But 90% are there for low-level crimes, even misdemeanors, some violations that aren't even jailable offenses, who are there for sometimes technical violations. And so that is a tremendous financial burden for all of the counties. The counties have been saying this for many years. And there have been efforts made in the General Assembly to attempt to stem the growing tide of the cost of incarceration. House Bill 463, which was passed a few sessions ago, was an effort to address in part the rising costs of incarceration at the state level. And right after the passage and enactment of 463, we saw a decrease in the number of persons being held pre-trial. Since then, unfortunately, the tide has turned again, and we're seeing a rise in the number of people who are being held pre-trial on a money bail. So it's important for us to address this. It is one of those issues, happily, that attracts both sides of the political spectrum, because fiscal conservatives are very concerned about the high costs of incarceration. And more folks on the other side of the political spectrum, of course, would emphasize that the Constitution does say that we are presumed innocent until proven guilty. And so those who insist that the presumption of innocence is ignored with financial bail. Folks who would say that not only is presumption of innocence ignored, but also that the fact that this system keeps poor people in jail. People who have money can get out. People who don't have money stay in jail. And the current emphasis for the court system is that even 3 days in jail is devastating. And we're going to take a hard look at that in the coming months to try to address that from the court's perspective.
Now, on that point of the 3-day count, I believe it's called.
Yes.
And to your point of the fact that these issues, including things like expungement and other justice issues, have been huge in the last couple of years, with people talking about ways to lower government spending on justice reform, as well as, their workforce issues as well. So what does the 3-day count issue mean? Tell me a little bit about it, and how can those address those two issues of fixing the justice system and the workforce problems?
The 3 Days Count initiative is, of course, a national. The Pretrial Justice Institute. This is their program, but we've signed on. We've received a grant from them to pursue the issue in Kentucky, to raise awareness of the fact that the 3 days is statistically significant. That's just enough time if one happens to have a job. You're likely to lose the job. You show up, if you're at an entry-level job and you don't show up for whatever reason for 3 days, you're going to lose your job. And so that presents that problem. There's interruption of the family relationships, all of the complications that arise from just 3 days in jail. And a 3-day jail term is not out of the ordinary, unfortunately, for many low-level offenders in Kentucky. And so this will be an effort to try to help educate the system, the judicial system, on the impact of 3 days in jail, and to try to find ways that we can address this with a way to deal with pretrial without imposing a money bail. The money is kind of medium across the board, and that is something we're going to address.
So now, when you talk about bail reform, or even potentially eliminating bail, to most people, I'm sure, without fully explaining it, it sounds like you're kind of getting rid of it for everyone. But that wouldn't be the case, right?
No. The people that, as I mentioned earlier in my discussion, 90% of the people that are in jail right now, in any given county, on any given day, based on our statistical research in the state, are there, but not because they're serious criminals. Obviously, the Constitution sets the right to bail for everybody, with the exception of capital offenses. If a person's charged with a capital offense, charged with murder, then obviously the Constitution would say that those people don't have a bailable offense. But everybody else who's charged with a crime is presumed innocent. All persons charged with a crime are innocent, but those offenses nevertheless are bailable because of the presumption of innocence under the Constitution. What has developed over the past decades is that we have set up a system where a person who's charged with a crime is automatically given a bail bond. An amount of money is assigned for that. And if the person can't pay the money, then they go to jail. And until they come up with the money. And often it happens, if they're low-level offenses, they'll stay in jail for several days. They'll finally see the judge. The judge will deal with the case, and the person's released from custody. So it's not because they are a threat to public safety, or a threat not to come back to court, or a threat to reoffend, or a threat to flee the jurisdiction. It's just because we have this default system of setting a money bail that keeps them in the jail. We need to keep the people in jail that we're afraid of. That the society is afraid of these people, and to keep them in jail. But we need to release the people if we're just mad at them for something. We need to find a way that they can be released from custody, go on about their jobs, pay their bills, take care of their families, and deal with their legal issues. Because statistically, we know that 85% of those people will come back to court no matter what.
So what do we do about this? Is this a legislative fix? Are there other means of doing this?
It's a combination. That's just why the court system's talking about it, the legislature's talking about it, and obviously the governor's talking about it. All of us need to be concerned about the roles that we play in our respective branches in feeding this problem. So for me, it's a matter of judicial education, For me, it's the ability for our pretrial services department to offer services for monitoring defendants that will satisfy the judge, because the judge ultimately has discretion about how to set the pretrial conditions until the case is disposed of. The judge feels has the responsibility of doing that. So our pretrial services at AOC, at the Administrative Office of the Courts, needs to be able to offer monitoring services that will satisfy the judge that not only have we done a statistical risk assessment, and we do that already. We have a risk assessment that we present to the judge when the judge is setting bail. Our pretrial services office will have already identified the person, will have interviewed the person, will have run a criminal background check, and will present to the judge what we call a pre-sentence or a pretrial report, which gives the judge a couple of tools. We will know, based on this person's criminal history, whether or not statistically he or she is a risk to reoffend while out on bail, or whether that person is a risk to flee. So we have those two tools available based upon statistical analysis of 250,000 cases that we have handled over time. We have done statistical research. We present this information to the judge, and so those are two tools the judge can use. We have those already. So I need to encourage the judges to use those because they are reliable. The judge then also, though, has the discretion, even with that information, to judge the case and decide what conditions this person needs to have in order to guarantee that they'll show up for court, that they won't reoffend, and they don't present a risk to the public while they're out pending the disposition of this case. So that's going to involve a considerable effort on our part for judicial education, because we're really going to have to turn this ship around, and it's not going to be easy. This system is very deeply ingrained in the system. So we're going to have to do some heavy lifting in that regard, and we're going to have to call upon the legislature. Obviously, we're going to need to beef up what the pretrial services office is able to do, and that's going to always involve money.
So tell me a little more about these new changes from PJI to the pretrial system. If they're coming to Kentucky, if it'll be implemented by AOC or through the legislative process, and
well, I think the 3 days count initiative itself doesn't really present any programs for us to adopt. It just gives us access to all of the information that they have gathered across the nation that we can use. Kentucky really is a model for lots of those, as I mentioned, because of Kentucky's unique situation of having operated a pretrial services department since the 70s. Then we have considerable background and statistical information that we can offer to the nationwide effort, and that's one of the reasons the 3 days count has been interested in us. But what we'll get from them is then some ways to maybe tailor our judicial education and any other. I mean, I'm sure that this will also involve conversations with prosecutors and law enforcement. They all have an interest. Obviously, law enforcement has an interest in having effected an arrest, in seeing that the arrestee is dealt with properly. The prosecutor has that same interest. Defense counsel has the interest to see that his or her clients are appropriately dealt with, their rights are observed, and we judges who set bail, want to be, we feel a responsibility not only to the system, but to the communities that we serve, that we do it right. And so doing it right includes not only making sure that that person is dealt with properly, but we need to recognize that there's a high cost to the community. If we make a decision to keep that person in jail, it not only affects that person, but it affects the taxpayers in the counties that we serve. And the jailers have been, and county judge executives in the state know better than I how expensive it is for us to house these people pre-trial.
Now, is there anything else that you want people to know about this issue, or anything we haven't covered?
I look forward to the opportunity to have further conversation, and I appreciate the interest of the Chamber in this, because it is a matter that's not just involving law enforcement and the courts. It involves citizens across the Commonwealth, the business leaders, because it does affect. We're spending tax dollars on pretrial incarceration that could be much better spent other places.
Absolutely. So now you guys have a couple other efforts going on, including the Civil Justice Task Force, and
Yes.
you guys recently made a trip to Arkansas. So tell me a little bit about what you guys are working on with that, and when we could see maybe some recommendations.
We have put together a pretty good committee. I'm really proud of the group. Justice Lisa Hughes from Louisville is chairing the group. We've tried to put together a group who would represent not only the legal community, but legislators as well, who have an interest in seeing to it that our courts perform as they should. And so one of the things we know is that the civil justice, those are the civil cases, the civil side of courts, is in need of attention. We were watching as more and more people come to court who are not represented by counsel. It used to be a matter that when I was a circuit judge in Bowling Green beginning in the early 90s, most of the people that I saw who were not represented by counsel in a civil case were people who just simply couldn't afford a lawyer. They were poor people. Well, it's a much more pervasive matter now. It's not just the poor people. These people are middle-class people, and they can't afford lawyers either. So lawyers we've priced ourselves out of the market in lots of ways, and so that leaves the system then to deal with non-represented people, which puts a strain on our system. Our judges would tell you it's much easier to handle a case in which both sides are represented by competent counsel than it is to deal with a case where one or neither of nobody is represented by counsel and nobody understands the processes and procedures in the court. So that's one of the issues that this civil justice reform. How can we, recognizing that the customer base, if you will, for courts is changing in these modern times, then how do we simplify the court process so that people who aren't represented by counsel can have their cases disposed of? We're seeing a decline, of course, in civil cases, caseloads, the jury trial that is so important that it's embedded deeply in the federal and state constitutions and described in the state constitution as a sacred right. Well, we're watching the number of jury trials diminish year after year after year, and more people are going to alternative dispute resolution, mediation, arbitration to have their cases resolved. And so that behooves the court system to take a look at itself and see what is it about the court system, about the jury trial system, that has become unworkable. Why are our customers voting with their feet to go somewhere else? So that'll be part of what the civil justice group is going to address. We know that the criticism is that civil court cases cost too much, and they take too long, and they're never over. Those are the three general criticisms of our system. And so we need to address that. And I would be hard-pressed to say to you that those three things aren't true. So how do we deal with that? And we should. And that's what this group is going to help us deal with. It's a big undertaking, but it's important. And I hope the Chamber will join us in this discussion. We believe that civil justice reform is a critical need in the state right now, and we need to be about addressing it. One of the goals of the civil justice reform would be to address many of the same issues that those advocates for tort reform are discussing, and that would be the expense of discovery, the lengths of delay in getting cases resolved, and ways to simplify the process that would make these cases, this courts, more accessible to all Kentuckians.